Thank you for joining this webinar. I'm Kent Roach, and along with me is the Honourable Harry LaForme, a former Justice of the Ontario Court of Appeal, who served from 2004 and 2018, and was the first Indigenous Appellate Court judge. Harry has recently been appointed to the Order of Canada. He also has honorary degrees from the University of Toronto, as well as other universities, and has also been appointed Indigenous Person Council. Before we continue, I'd like to do the land acknowledgement. For thousands of years, we're speaking to you from the traditional land of the Huron-Wendat, the Seneca, Mississaugas of the Credit. This meeting place is the home to many Indigenous people across Turtle Island. I am particularly grateful for having been able to learn from Indigenous people throughout my career, and we're grateful to be able to live and work on this wonderful land. Following our discussion, and I'll talk probably for about 25 to 30 minutes, we will, and then Harry will talk for about 15 minutes. We will then open for Q&A. I'm also happy to tell you that through the Office of the Alumni Affairs, and I thank them very much for arranging this, if you are participating, you will get 1 hour of Law Society of Ontario professionalism credit towards your continuing education. And for that reason, I will try to focus on some of the ethical issues surrounding wrongful convictions. Next slide, please. Next one. So
sorry, I'm just having some technical difficulties.
Sure.
1 second.
So what I'm going to talk about, and what Justice LaForme is going to talk about, is really a kind of sad story. So I wanted to start with a somewhat happier story. And this is a picture that is taken in 2018 at the Innocence Project conference in Memphis. And I went there with Amanda Carling, who was then the manager of Indigenous initiatives. Very much we had co-taught wrongful convictions as equals. Amanda was my former student. She changed the course for the better. And she was very much the driving force behind a project assisted by U of T law students who then became lawyers, where we compiled the first Canadian registry of wrongful convictions. We went to Memphis, and this is a picture of us marching. This is in Trump's America, coming up on the 50th anniversary of Martin Luther King's assassination. And this is at the start of our march, which ended at the Lorraine Motel. And if any of you are ever in Memphis, it has now been turned into an extremely powerful civil rights museum. It's also eerily just like the photos that are all engraved in our mind of Reverend King being gunned down on the second floor of the Lorraine Motel. So we went to Memphis to talk to people from Michigan State, University of Michigan, who had founded the American Registry of Wrongful Convictions. And they were very kind to us and gave us a lot of guidance throughout. And so we came home, this is about May 2018, I guess 5 years ago, thinking, oh, well, we'll put our heads down, and within a year we'll have a Canadian registry of wrongful convictions. Amanda wanted this very much because, as a Métis woman and with her work with Innocence Canada, she was convinced that Indigenous people have special challenges in correcting wrongful convictions, barriers, systemic discrimination and racism barriers. I was also concerned about that, but I was also concerned that we were suffering something that I call wrongful conviction amnesia. And if you move to the next slide, this is one of the reasons why I've written this book, which was published last month by Simon and Schuster. And you'll be able, through U of T bookstores, to get a 25% discount on the book by using the code 25 Kent Roach. But one of the reasons why I wrote this book was that as DNA exonerations have dried up in Canada, then, to borrow the words of the Tragically Hip, wrongful convictions are not late-breaking news on the CBC. But that doesn't mean that wrongful convictions still do not happen. Thomas Yebbies, and those of you who practice criminal law will know Yebbies as a famous 1987 decision from the Supreme Court of Canada that basically affirmed the idea that appellate courts should not second-guess jury verdicts. Mr. Yebbies' murder conviction was overturned in 2020, but was only reported in one article that we could find in the Globe and Mail. Similarly, other wrongful convictions being overturned, the most recent being Richard Clausen's in BC, where the Crown, I think regrettably, decided to enter a stay as opposed to allowing him, after he had received an order of a new trial from the Minister of Justice, Lametti. That has not been reported in the national media. I wrote a piece recently in the Vancouver Sun about that and other recent cases where prosecutors have used stays despite recommendations by 3 public inquiries between 2006 and 2018 and 8 that in a case where there's a wrongful conviction, which we define in the registry as any conviction that is then subsequently overturned on the basis of new evidence, that the recommendations were made by 3 public inquiries that prosecutors should only use prosecutorial stays under Section 507 of the Criminal Code if there is a realistic prospect that the person will be prosecuted again. And of course, using a stay for someone who has endured the stigma and suffering of a wrongful conviction puts them in legal limbo and allows suspicions to gather over them. So for all of these reasons, I decided to write this book. It would not have been possible without the Canadian Registry. It would also not have been possible without having worked with Justice LaForme and Justice Westmoreland-Traoré in the summer of 2020, when the Minister of Justice asked the 2 justices to do public consultations on creating a new Miscarriage of Justice Commission. And during that summer, and Justice LaForme may speak to this, we heard from over 225 people, and we started with the exonerated. And that was extremely important in reminding us that there is human suffering behind all of these stories. Next slide, please. So what the registry allowed me to do, I have taught a course on wrongful convictions since the early 2000s. And before the registry, it was taught in a relatively traditional way, pioneered by Peter Neufeld and Barry Scheck of the Innocence Project in New York, where we would focus on all of the immediate causes of wrongful convictions: mistaken eyewitness identification, false confessions, police tunnel vision, prosecutorial tunnel vision. When we stood back after collecting data on 83 remedied wrongful convictions, and we're only looking at remedied wrongful convictions, so this is the tip of the proverbial iceberg, there were some patterns that, frankly, I had never seen before. The first is 15 of 83, although we are now expanding to 87 wrongful convictions in the registry, and it will very soon be 16 out of 83, were actually guilty pleas. This is a picture of Dinesh Kumar, who was a recent immigrant from India, who pled guilty to manslaughter when originally charged with murder in the death of his son. And this was a case involving testimony from the discredited pathologist Charles Smith. Mr. Kumar was one of 8 people whose guilty plea wrongful convictions have been corrected and were attributed to the involvement of Charles Smith. Next slide, please. So of the Charles Smith cases, 5 were women. Many were very young women who had caught the attention of children AIDS authorities. 3 were racialized men: Mr. Kumar, Richard Brandt, who is a Mohawk, and Onell Blackett, who is a Black man. We've also saw false guilty pleas in 2 other cases involving Indigenous men: Clayton Boucher from Alberta, Richard Catchaway from Manitoba, who made rational time-served decisions to plead guilty. In Mr. Boucher's case, he pled guilty because he just had to get out of Edmonton remand after serving a number of months. He pled guilty to drug possession. His wife had tragically died in a traffic accident while he was denied bail and detained in remand. And he was allowed to attend his wife's funeral, but in cuffs. After that, he kind of gave up. It was only subsequent to his guilty plea that it was discovered that his claim that the drugs that the RCMP discovered were not drugs was actually true, that the RCMP lab affirmed that it was not drugs. Mr. Catchaway is an Indigenous man from Manitoba who we know through publicly available records has been diagnosed with FASD. He pled guilty, got time served for a break and enter. The only problem was it was later discovered that he was imprisoned in Brandon at the time of the Winnipeg break and enter. The registry, again, only mentions remedied wrongful convictions, but my book goes beyond that and talks about the Wilfred Brosseau and Jamie Gladue cases, where there were, in Mr. Brosseau's case, a plea to non-capital murder, and in Ms. Gladue's case, a plea to manslaughter, although she was charged with murder, that may well have been guilty plea wrongful convictions. Next slide, please. So the issue from an ethical perspective is how do we make sure that we don't pressure and essentially coerce people into accepting a plea and sentencing discount? The late Justice Mark Rosenberg, Justice LaForme's former colleague, spoke about this in the Hannemeyer case. But this really raises, I think, difficult ethical issues that are not really contemplated in available rules of professional conduct about what is the role of the defense. Should the defense plead someone guilty who is maybe making a rational decision in their benefit, but actually has told them that they are innocent? What is the role of the prosecutor? The FPT heads a prosecution report, the most recent one in 2018, has said that prosecutors should not accept guilty pleas from those that they know to be factually innocent. Is that the appropriate standard? And now the role of the judge, because under Bill C-75, the criminal code has been amended so that the judge is supposed to determine whether there is a factual basis to the plea. But of course, it is very difficult to reopen pleas once they have been made. The wrongfully convicted told me and Justice LaForme many times it can take literally only minutes for a wrongful conviction to occur, especially in a guilty plea case, and it can take decades to undo that wrong. And if you look at the Supreme Court of Canada's decision in Wong, which sets out a very restrictive subjective test, i.e., would the person have pled guilty if they knew about, say, undisclosed evidence? A lot of the Charles Smith victims still maintain that they would have pled guilty because it was the best thing for their family. Similarly, Jamie Gladue might have still pled guilty because she had 2 young children at the time, one that she even named after her late husband that she may have killed in self-defense. So there's an issue on, with Jordan and the like. There's a lot of emphasis on efficiency and finality. But one of the costs of that, and perhaps one of the costs of increased denial of bail, will be that some people will make rational or perhaps irrational decisions to plead guilty, even though they are innocent and they may well have a valid defense. Next slide, please. The second part of the book, and again, this is revealed by the Registry, talks about imagined crimes. This is Tammy Marquard. She is an Anishinaabe woman. She was offered a plea to manslaughter in the death of her son, Kenneth, who she is holding a picture of. One of her lawyers told her, take the plea. The other lawyer told her not to take the plea. She went to trial, and as she later told Kirk Macon, the truth didn't set me free, it gave me a life sentence. Next slide, please. So crimes that did not happen are about 1/3 of remedied wrongful convictions. And so now I know, and certainly after reading the reader's comments beneath an op-ed that the Globe and Mail reran yesterday, I know that people are very concerned about crime and are not favorably disposed to people like myself who are professors. But even assuming that there are crime problems and that, we're not going to dispense with the criminal justice system, because, that would obviously be one way of ending wrongful convictions. What about cases where no crime was committed at all? The fact that 1/3 of remedied wrongful convictions, no crime occurred, suggests that this idea associated with Charles Smith of thinking dirty, trying to find child abuse because it had gone underreported, is also something that is much more broadly spread. It's not limited to Charles Smith. It applies to stereotypes that associate various disadvantaged groups with crime, but it also applies to circumstantial evidence. So the proverbial man who is maybe having an affair. Judge Jacques Delisle was convicted of murdering his spouse, and one of the things that he said to the police very early on, I know what you're thinking, but I didn't do it. And that was in part because his story was that his wife committed suicide. She had suffered a severe stroke, but at the same time, at the time, Mr. Delisle was also having an extramarital affair. So the issue of imagined crimes, I think, raises the issue of, yes, the presumption of innocence is a legal principle, a very important legal principle, but is it also a social fiction? Next slide, please. And then finally, and I deliberately left this to the last part of my taxonomy of wrongful convictions, is the whodunits. And the whodunits are where we get the wrong person. And one of the reasons why I left it to the end is that the whodunits are the most well-known of our wrongful convictions. They're also fodder for Netflix entertainment. I don't know if people know who this is. This isn't the most famous picture of this man who was a very important representative and leader of the Mi'kmaq community. This is Donald Marshall Jr. as he is being arrested at 17 years of age for the killing of a Black teenager, Sandy Seal, where the police basically framed him, and where the real killer, Roy Ebsery, was revealed a few days after Mr. Marshall's conviction, but it took 10 more years to get him out of the maximum security Dorchester Penitentiary. Next slide. And then the second whodunit, and we will be coming back to David and Joyce Milgard's story, is obviously this, where Mr. Milgard was wrongfully convicted of a terrible rape and murder in the early morning in Saskatoon. He served 23 years in jail, and during that time, the real perpetrator, Larry Fisher, went on to commit other terrible crimes of sexual violence. Next. So one of the issues with the whodunits is there is the danger of waiting for DNA. And the DNA that exonerated David Milgard only came in 1997. And even though the Supreme Court of Canada said basically it was unsafe to keep him in jail and to sustain his conviction in 1992, between 1992 and 1997, Mr. Milgard lived under this cloud of suspicion, and he had a very difficult time. He tried to sue people that maintained that he was guilty. The fact that the Tragically Hip wrote their song Wheat Kings in 1992 contributed to the exoneration process, which is partly a social as well as a legal process. But Mr. Milgard really suffered during that time. And in fact, the DNA that cleared him could very easily have been destroyed. In fact, incredibly, it could have been destroyed under the recommendations of the Milgard Commission that looked into his wrongful conviction, which in 2008 recommended that biological material only be maintained for 10 years. It was simply a court clerk who thought that Mr. Milgard had been wrongfully convicted and who took special care to make sure that the material with Larry Fisher's DNA on it was maintained. So one of the things that we need to do is think about countering tunnel vision, or what psychologists call confirmation bias. One of these tools, and this is an area where you can have a win both in preventing wrongful convictions, but also in controlling crimes, is to use case management and other tools like victim linkage, which provide some remedy against what is a natural human tendency to simplify the information that we receive. The way that I explain tunnel vision to my students, and you can be sure they don't appreciate it, is if I'm reading a 3-question exam and the first question, the student doesn't do so well, then I have a subtle confirmation bias that maybe the next couple of questions aren't going to be as well. There's really not a lot that I can do about that except try my best to keep that in mind, perhaps mark the questions in different orders and so forth. Another problem that we have, and I discussed this in relation to the Glen Assoon case, a remedy wrongful conviction, and the Philip Tallio case, whose request for a remedy was denied by the BC Court of Appeal with leave denied to the Supreme Court of Canada, is the difficulties of pointing to alternative suspects. Once there has been a focus on the wrong person by the police, it's very difficult at trial and very risky to point to an alternative suspect. So we have to get the policing right. Next slide, please. And then finally, we go to what must be done. I realize that I'm getting older, probably getting near retirement. I don't know the age of everyone who is watching, but for me, this was a picture I very much wanted to be included in Wrongfully Convicted. I also suggested to Justice LaForme and Westmoreland-Traoré that it be in the cover of their report on a Miscarriage of Justice Commission, which I commend to you for reading. But better heads prevailed. And for some reason, this picture, which I think is part of Canadian history, has not been produced in a form that could be reproduced in the book, although the book does contain pictures. It's the first book I've ever written, probably the last book I've ever written that will have pictures in it. But this is Brian Mulroney talking to Joyce Milgard, and you can see it was a different time because look how close the reporters are. In 1991, in the lobby of a Winnipeg hotel, and Mr. Mulroney went over to talk to Joyce Milgard. Joyce Milgard, David's application to then Minister of Justice Kim Campbell had been denied, his first application. And what Joyce Milgard was telling Brian Mulroney is something that I think we all hope that our parents, perhaps our mothers especially, would do. And that is, she is telling Mr. Mulroney, my son is innocent. She's also saying, my son is suffering in prison. Please have him transferred to a minimum security prison. I'm afraid he's going to die in prison. So that is what Joyce is telling Brian Mulroney. Within a matter of months, whatever she said worked, because within a matter of months, David Milgard is transferred to a minimum security prison. And a new reference is ordered by Minister of Justice Campbell. The Milgard Commission tried to find out what exactly happened, but the federal government resisted it. So they had to rely upon the memoirs of what the tragically hip call in Wheat Kings, Our Parents, Prime Ministers. And Mr. Mulroney's memoir says he directed Kim Campbell to have a reference. Kim Campbell, Miss Campbell's memoir says that she made the decision independently. So we probably will never know what happened. And this is part of the reason why the 690 and now 696 process of applying to the Minister of Justice for a new trial or a new appeal is so mysterious. this episode, although it worked, and I think that's important to remember, does cast a pall over the whole process. Next slide, please. So what must be done? Well, first, obviously, it's better to prevent wrongful convictions than to remedy them. Although at the same time, but we've done relatively little. There's been 7 provincial public inquiries into wrongful convictions. They've all recommended various reforms to the criminal code, and almost none of those reforms, in fact, none of those reforms have been enacted. So the Donald Marshall Jr. Commission said we should have statutory disclosure rights to the accused in the criminal code. The government did nothing. Of course, the Supreme Court intervened with the famous Stinchcombe case. We still have no legislated standards, or we do not routinely allow expert evidence on eyewitness identification. Faulty eyewitness identification is one of the leading causes of wrongful convictions. It's extremely difficult to get at because a person can honestly believe that that is the person. We're just really bad at recognizing people and then retrieving it in our memory. That retrieval process is often tainted by the fact that we've gone through identification procedures with the police and then subsequently at trial. In Jason Hill's case, Hill versus Hamilton Wentworth, the Supreme Court recognized that there is a tort of negligent police investigation, but they held that it was not made out in Mr. Hill's case, even though the way the police conducted the identification was terribly, terribly flawed. And I don't know if Justice LaForme will be willing to talk about that, but along with Justice Feldman, he issued a very compelling dissent. We also have the false promise of judicial regulation of interrogation and Mr. Biggs. Again, false confessions can come out even after the Hart case. Now, most trial judges are allowing in Mr. Big. I know that both Innocence Canada and the UBC Innocence Project are working on Mr. Big cases that they believe are wrongful convictions. There's also the false promise of reforming forensic science, province by province, discipline by discipline, issues of evidence retention, the fact that our appeal courts will not generally allow appeals on the basis of a lurking doubt or the safety of the conviction. Next. So I think we can and should do more to prevent wrongful convictions. One of the things I look to here is the legal philosopher Ronald Dworkin, who argued you have no absolute right to the most accurate criminal justice system. And this, builds on the idea that if we really wanted to get rid of wrongful convictions, we would get rid of convictions entirely. But Professor Dworkin, I think to his credit, said there's an important caveat. If the risk of wrongful conviction falls disproportionately on disadvantaged groups, then you would have a right to the most accurate criminal justice system. And of course, we know that Professor Dworkin's philosophical caveat is a sociological reality, whether it is Canadian registry or the American registry or the British registry. We know that the disadvantaged, who are of course also overrepresented in our prison population, are most at risk of wrongful convictions. So we need to improve and quicken remedies. Bill C-40, which is before Parliament just for first reading, proposes to replace the role of the Federal Minister of Justice with the new Miscarriage of Justice Review Commission. I'll let Justice LaForme speak to that in greater depth, but there are concerns about how people will be appointed to that commission, whether they'll have the necessary budget powers and jurisdiction, especially in wrongful guilty plea cases and in sentencing cases. Next. So I leave us with this unfortunately sad picture of the late David Milgard. And I'll let Justice LaForme maybe speak a little bit about the encounters that we were fortunate enough to have with Mr. Milgard before he passed away. Note that this picture is taken in Innocence Canada's office. Innocence Canada is our leading innocence project. Note that beside him is the picture of Mr. Kumar, who I've showed you, and then on the other side, although you can't see it as well, is a picture of Tammy Marquardt. So with these sad but real stories, I'd like to turn it over to my teacher and my friend, Justice Harry LaForme. Harry, you got
I want to thank you, Kent, for I was muted, of course, like always. Anyways, I wanted to thank you for that, and I wanted to thank you especially for the introduction and the land acknowledgement. I'm kind of biased about the land acknowledgement. I usually say it's the treaty territory and traditional territory of the Mississaugas of the Credit, because that's where I'm from. So I have a bias in that regard, but I want to thank you for that. And I also want to point out that I was a trial judge for 10 years before I went to the Court of Appeal. So I spent 25 years on the bench, and 14 of them was as a Court of Appeal justice. And I thank you for the references to Hill. There's a couple of others that I was involved in, because one of the things that I think it's really, really important to note is that I was involved, as you pointed out, in the consultations on an independent process for studying wrongful convictions. And we did engage with the exonerees first. And that had a really, really profound effect on me. I was really touched by their stories. I was touched by their sincerity. My gosh, virtually every one of those people, you had a difficult time appreciating that they weren't talking about themselves. They were talking about others, how to prevent wrongful convictions. They didn't dwell on their own. And I found that really rather incredible. The other thing that is really interesting about that, and I may have talked to you about it, is being a judge for 25 years, you hear that, the stories of the exonerees, and you wonder if as a judge you ever made a contribution to that. And that was really troubling. I'm happy to say that I don't know if that's true. I don't know if I did, but I do know that there are cases which has been brought home to me since I tabled the report with the minister, that where they remind me that I wasn't like that. I didn't make that kind of contribution. And I, in fact, was really, really adamant about my decisions when there was a lurking doubt, for example, or when I suspected that this just isn't right. And sometimes you have to be creative in your writing, but nevertheless, so I really appreciated that with people. And there was Jason Hill's case, for example, and I remember that all too well. And I think the world of Justice Feldman, who I was happy to join in that dissent. And she, she was very adamant about her dissension and in that whole case. So a lot of reality hit home on that, and I've become a real advocate for this issue and the wrongful convictions. And I've read your book, and I've even commented on it. The comment is out right on the cover, in fact, and I mean that more than anything else. That it is a wake-up call to all Canadians, and I hope when we're finished with this conversation today, that people will realize that there's a lot that people can do. And one of them isn't to just sit back and allow this to happen. You have to get out and you have to do something, even if it's a letter to your member of parliament. I don't know, but it's a very, very important subject. And it's troubling. It really is troubling to the effect that how often we do this in Canada and how often we are troubled by. One of the things I learned about being a judge is that finality is really important to our system of justice, and finding finality is critical. And we don't like to be told we're wrong, and we don't like to be told we made a mistake, but we do. We're humans, and we have to know that. And I guess what we have to know is the degree to which we make these mistakes. It's far greater than anything we think about. As an example, we have had a criminal case review commission now for over 20 years. And in that period of time, we've asked the court to review, and we're concerned about 20 convictions. That's one a year. One a year. We know that is absurd. We know that we're far greater than that. Well, during our consultations, did we not only start with exonerees, but we included in that, as you recall, Kent, every commission in the globe right now that exists. We did it with the newest, which was in New Zealand, and then it was North Carolina. In case anybody is wondering that the United States may be blind to this, they're not. They're not. They're very alive to this issue. And then we had London, England, and we had Scotland, and the Netherlands was another one. And so we examined all these commissions, and they were very helpful. They told us that funding and the right commissioners were important to anything you do. So we tabled our report to the minister in, I think, 2021. I know it was my birthday, actually. And we had reviewed, I don't know, you commented on it a little while ago. We had 45 roundtables, 215 people, 17 survivors. We received 45 written submissions from individuals and organizations. We submitted a 212-page report to the Minister of Justice Lametti on October 2021. And Bill C-40 now supposedly took our consultation paper into consideration, and they say seriously, and they proposed something that I thought initially was maybe a good start. We can do this as a start, and that'll be good. It's at least out of the hands of government. I've since reflected on it and looked at it, and I don't believe that's the case at all. It can be, if you're lucky, if you're fortunate, it can be an answer, a small answer. But in terms of reality, I question whether it's the answer. We had, after our report went out, we had Carrie Leonetti, an associate professor at the University of Auckland, and she an associate professor of law in New Zealand. And these are some of she studied this commission and our submissions to Justice Lametti and our consultation paper. And she made a comparison to all the other commissions that are out there around the world. And she says that hopefully the Canadian, and she wrote this in a paper that she had published, hopefully the Canadian government will seize this singular opportunity to implement a monument to justice and place Canada as the global leader in addressing wrongful convictions. That's pretty heady stuff. You know, it's a detailed print for transformational CCRCs. And you're hopeful that this is what will happen, but that isn't what happened. So what we get is a commission, and I even got, I guess, a little disappointed in the name of the commission, because what we were told initially, as you recall, Kent, that review commission and a criminal cases review commission is not what we're about. We suffered an injustice and we're about miscarriages of justice. And we didn't want review, we wanted investigation. That's what these exonerees told us, and they were, to a person, said that. So we wanted the name of whatever the government was proposing to be Miscarriage of Justice Commission. They couldn't even do that. They had to put review in it. It's now called Miscarriage of Justice Review Commission. And that's, to me, that's a slap in the face of the exonerees, because, and we told them specifically in the consultation document why we wanted the name we wanted. And that was disregarded. So here we have Miscarriage of Justice Review Commission. That isn't, I don't think that is going to warm the hearts of wrongfully convicted people, but I think they're going to be, I don't know if they will be satisfied with this or not. It's something we're going to have to deal with. But what I thought were the two very important components, and this could still happen. I doubt it, but it could. The commissioners themselves have to be the proper people. We wanted 9, I think, was the commissioners that we wanted. And we wanted specifically one Indigenous person and one Black person on the commission, because they represent the over-incarcerated people. And you got to believe they represent the most of the people that are wrongfully convicted. I can tell you from my experiences that wrongful convictions of Indigenous people have to be massive. They have to be just incredible. And they're not for serious crimes, although that seems to be what gets through to the process that currently exists, is a serious crime. But these are people that have records that are pages long because of it. Guilty pleas, as you say, they sit in incarceration for 2 or 3 months while awaiting their review or something like that. It may be their first appearance or their bail review. And they're sitting in there and they're given a choice. You can do this with 13 different offenses, plead guilty, and you'll be out, you'll be gone. Well, to an Indigenous person from a fly-in community, that's very, very important. They have a family to take care of in most cases. They have to get out. They need, and in many cases of wrongful convictions, you know yourself in your book, you talk about it, is that a lot of people are given choices that are almost impossible for them to say yes to. I will plead guilty. Like who's the guy, the East Indian man who was you muted.
Dinesh Kumar.
Yeah, that's right. He pled guilty because he was threatened with deportation and to be taken away from his children and his family. What would you say if you're given that choice? You do this, you plead guilty to this, and you're gone. So we wanted a commission that had these people. Well, that's not what we got. We got a commission now that is up to, I think, 7 people, maybe, I don't know, 5? Was it 5?
Yeah, I mean, it is possible that it could be as low as 5 with 4 part-time commissioners and
Well,
1 full-time commissioner who also has to be the chief executive.
yeah. And there's no guarantee that any Indigenous or any Black person will be on it. I don't know the process that they're going to appoint these. We, in our consultation document, said it should be an independent body made up of exonerees and et cetera that could talk about who these commissioners were. We had advocated only part of them be legal. We advocated that part of them be forensic scientists and things like that with knowledge of wrongful convictions and the reasons. None of that is there. None of that is there. I don't know, but I think I have to believe Minister Lametti when he says, don't worry, one of them will be Indigenous. I don't know if that's true or not. I have no way of knowing. I don't even know if he's going to be the one to make the decision. So there you go. We have this commission where we don't know who will make it up. Maybe this will be from the usual people that get selected to do inquiries and stuff like that. And we don't want them. We want people that have an expertise and a knowledge about wrongful convictions. Anyways, we have to trust the government on that. And the chief commissioner has to be the chief executive officer. That means he has to be what we call a deputy minister. And a deputy minister is part of government because they have to comply and make sure that the commission complies with all the financial requirements and everything that go along with that. That's a full-time job. You almost have no time to think about wrongful convictions. You're doing everything in the administrative field. So I'm sorry, but I really think that that commission is set up wrong in the terms of its representation for commissioners. I don't know. Well, we have to trust at this point. We have to trust a lot, I think. And even if we do get that, Indigenous person as a chief commissioner, as a lead commissioner, he'll be so busy with his administrative responsibilities of government, and government will tell him what his budget is, will tell him how to spend his money. All that is there. He'll have to abide by all of that. And, you know, we were talking about, like, if you represent Indigenous people, and I'm dealing with that a little bit right now, and I dealt with that before as commissioner of the Claims Commission. But sometimes when you want representation or you want submissions from people, you want them to come and tell you what happened or anything. They bring an elder, or they bring a drum, or they bring ceremony with them to these. I don't know how they're going to pay for that. I don't know if they're going to pay for that. We used to just, in terms of when I was at the Truth and Reconciliation Commission, for example, I refused to be a deputy commissioner because I didn't want to be bound by all their strict rules of expenditure. And I wanted to be able to give the elders that came to the commission a per diem, something that acknowledges their importance and something that acknowledges them taking their time out to approach the commission. In any case, I wanted the same thing. The other part of the equation, and I think these are the two most important parts at least, are the commission itself, and you've heard my comments on that. The other one is the budget. I have no idea what the budget is going to be. It's going to be in the usual cases, how they fund commissions and how they fund separate departments of government and everything like that. It's going to be, you have to submit your budget to I don't know who, Treasury Board or something like that. They'll decide whether you're correct, and they will decide whether it fits or anything like that. You'll have to justify this, justify. So I don't know what the budget's going to look like, even for that first year.
Yeah, and I mean, if I can interject, I mean, we talked to the New Zealand commissioners, and you know, they were off to a great start. They had, you know, by law they had one. They actually had 2 Maori commissioners, a Pacific Islander commission, and they had the best of intentions, but they also had a budget that turned out to be inadequate. And because of that, they've only referred one case, even though they've been operating since 2020, and that was a sentencing case. And one of the things that Harry and Juanita recommended was we include sentencing, and that we also not require appeals to be exhausted in all cases. Because a lot of these false guilty plea cases, it's not realistic to expect a person to go through one, perhaps two levels of appeals. So, I mean, I realize that we only have 3 minutes left and that people probably have to get back to their work or their afternoon. But I know this has been kind of a sad, even pessimistic, but one thing I would add is the bill is only at first reading. And so this is something, it is going to go to committee, and this is something that could be improved. There's also, frankly, a chance that the bill could die on the order paper, depending on when the next election is called. And so both Justice LaForme and Westmoreland-Traoré's work and my book are, directed at calling attention to this. And so if you're interested, I echo Justice LaForme's idea that it's not too late to get involved and to contact people because this is it's named after David and Joyce Milgard. We talked to David Milgard 4 times during that summer, and he was so generous with his time. He was generous. I mean, it was the same thing that Harry was saying, is he said, let's not close the door to sentencing cases. Why? Because I've been in prison and I know that prison's a bad place. I mean, he just had an absolute heart of gold, and he gave and he gave and he gave. And
don't think, Kim, don't think, Ken. I don't ever think. I knew Donald Marshall Jr. His wife and I are very good friends, and I heard about it when he died. David Milgard is the same thing, and every one of those families and everything say their time in prison contributed to their early death.
Absolutely. Yeah.
Yeah.
Okay. Well, on that note, I realize that we're almost out of time. I thank you very much. And just remind you that if you're interested in getting the book and you want to order through the U of T bookstore, you'll get 25% off. And it's 25 Kent Roach is the discount code. I sound a little bit like I'm on TV selling things, but I would very much like to thank Justice LaForme for joining with me. We've had a great journey, and we continue to have a great journey on this. I would like to thank all of the people, Nina and others at the U of T Alumni Affairs, and most of all, I'd like to thank you for sharing this hour with us, and I look forward to hearing from you. Goodbye.